those of you that I may not know, my name is Dana Clark, and I am the Associate Dean here at Trinity. I'm also privileged to act as the faculty advisor to the Federalist Society chapter here on campus. This evening, we have the pleasure of introducing two gentlemen that are well known in their fields, Dr. Ryan T. Anderson and Professor Myron Steeves. The topic for this evening will be on illiberal liberalism and same-sex marriage. We were to have a third panelist this evening, Professor Deloach, but for those of you that may have not heard, his wife just gave birth to their first child, a little boy named Augustus, and so he couldn't be with us this evening. Our format for this evening will begin with a presentation by Dr. Anderson, which will be followed by some comments by Professor Steeves. We may actually have some time left for some questions and answers as well, and then the chapter president, Matt Camphouse, will wrap up for us. With that being said, Ryan T. Anderson is the William E. Simon Senior Research Fellow at the Heritage Foundation and the founder and editor of Public Discourse, which is the online journal of the Witherspoon Institute of Princeton, New Jersey. He is the author of When Harry Became Sally, Responding to the Transgender Moment, and Truth Overruled, The Future of Marriage and Religious Freedom. He has also co-authored What is Marriage, Man and Woman, A Defense, and Debating Religious Liberty and Discrimination. Dr. Anderson's research has been cited in two Supreme Court opinions, one which was authored by Justice Thomas and the other Justice Alito. Dr. Anderson earned his Bachelor of Arts degree from Princeton University, graduating Phi Beta Kappa and Magna Cum. He then earned his doctoral degree in political philosophy from the University of Notre Dame, where his dissertation was entitled Neither Liberal Nor Libertarian, A Natural Law Approach to Social Justice and Economic Rights. He is a member of the James Madison Society at Princeton University, a fellow of the Institute for Human Ecology at Catholic University of America, and a visiting fellow at the Veritas Center at Franciscan University. He has appeared on ABC, CNN, CNBC, MSNBC, and Fox News. His writings have been published in the New York Times, the Washington Post, the Wall Street Journal, and the Weekly Standard, as well as the National Review. Please welcome with me then Dr. Ryan T. Anderson. Our second panelist, as I mentioned, is our own Professor Myron Steeves. Professor Steeves received his Bachelor of Arts degree in Intercultural Studies from Biola University and his Juris Doctorate from Georgetown University Law Center. Prior to attending law school, Professor Steeves served as a missionary in the Middle East and India. His law practice is now concentrated in transactional work for nonprofit clients and general business litigation. Professor Steeves began teaching at Trinity's predecessor law school, Simon Greenleaf, in 1992. And he became the Director of Development and Alumni Relations in 2008. Thereafter, he served as Dean of Trinity Law School from 2010 to 2016. Professor Steeves has taught classes in a variety of subjects and currently concentrates his teaching in the area of constitutional law. Please welcome and thank Professor Steeves. And with that, I will turn over the podium to Dr. Anderson for his comments this evening. Thank you for being here.
Thank you. Well, thank you all for coming, and thank you, Dean, for the kind introduction. I want to spend a little time in kind of the prepared remarks delineating ways in which Americans have combated discrimination historically without trampling on other civil rights. Because what I want to suggest is that we're now seeing something new in American history with an illiberal form of liberalism, in particular in which civil rights laws and other anti-discrimination laws aren't being used as shields, shields to protect people from discrimination, but they're being used as swords, swords to punish people who hold the wrong views. About 3 or 4 months ago, Rolling Stone ran a profile of Tim Gill, a multi-millionaire who has pledged $500 million to passing sexual orientation and gender identity non-discrimination laws. And the reason why, he said, was to, quote, punish the wicked. And he was explaining to the journalist who wrote the profile of him that they were going to go into the deepest southern states to, quote, punish the wicked who were homophobic and transphobic and otherwise wicked. So let me start by, I want to delineate 3 different types of cases in which we can think of anti-discrimination laws. And then I'm going to wrap up by applying some of this to the Masterpiece Cakeshop case. I imagine most of you are familiar that back in December 5th, the Supreme Court heard oral arguments in Masterpiece. It involves a evangelical baker who was asked to do a custom wedding cake for a same-sex wedding. He said he couldn't do that because of his religious beliefs, and then he was found guilty of having violated the Colorado human rights statute. So I'm going to wrap up by getting to that case and some of what was said at oral arguments. But I want to start by taking kind of like the clearest, easiest kind of focal case of discrimination and anti-discrimination law, which would be racial discrimination. So think about the United States context, or the American context more broadly. For several hundred years, we enslaved people based on the color of their skin. After the abolition of slavery, we then legally segregated people based on the color of their skin with Jim Crow laws. Whereas marriage had been a colorblind institution prior to the development of race-based chattel slavery, the US colonies were the first political institutions in human history to ban interracial marriage. Because the idea here was that they knew that men and women of different races could unite as one flesh and could produce children. They didn't want that to happen. It's not that they thought interracial marriage was impossible, it was that they thought it was bad. And the reason why they thought it was bad was the same reason that they were enslaving black people to begin with, was a noxious notion of white supremacy, that whites were morally superior to blacks, that whites were intellectually superior to blacks, and therefore white and black shouldn't commingle on an equal basis. If you think about the nature of marriage, it's an equal union of spouses. They couldn't allow that to happen. They also couldn't allow the creation of interracial children, because very quickly that would undo an unjust system of race-based slavery. So we have several hundred years of race-based slavery. Then we have about 100 years of race-based legally mandated segregation in the form of Jim Crow. We have anti-miscegenation laws, which are denying a common law liberty. Under the common law tradition, interracial marriage was a liberty. Now we have legal statutes forbidding interracial marriage. Those are struck down in Loving. And so as a response to this wicked legacy of white supremacy, of racism, of the incidents and badges of slavery, Congress passes the Civil Rights Act of 1964. And it says you can't discriminate on the basis of race in public accommodations. And then we have other civil rights laws that would apply this to other categories, education, employment, things like that. It doesn't have robust religious liberty exemptions. It doesn't have conscience exemptions. What Congress does here, and then many states also pass their own civil rights statutes to ban discrimination on the basis of race, it says that you can't take a factor into consideration, someone's racial identity, ethnic heritage, skin color, in order to treat that person less than equal. Especially because we can't think of where someone's racial identity, ethnic heritage, skin color would make a difference with respect to service at a public accommodation, or with respect to employment, or with respect to housing. Our skin color is irrelevant to those sorts of things. So, for example, whereas we once had bans on interracial bathrooms, Congress strikes that down, but it didn't strike down separate facilities for men and women. So let me pivot to the second example of anti-discrimination law. Sexism. The United States also has a bad legacy of sexism, in which men were encouraged to go to college to take courses in economics, and women were encouraged to take courses in home economics, in which men were afforded educational opportunities that were denied to women and to girls, in which men were afforded athletic opportunities, which were denied to women and girls. So in 1972, Congress responds to this form of injustice by passing Title IX to the Education Amendments. And it says you can't discriminate on the basis of sex. And what it means by this is you need to have equal educational opportunities for both male and female students, equal athletic opportunities for both male and female students, but you don't have to stop having separate facilities for men and women. So Title IX explicitly says that you can have separate housing facilities for men and women when it comes to, let's say, dorm rooms on a college campus. And then the implementing regulations extend that principle to bathrooms, to locker rooms, to sports teams. And so you can see right there in this 1964 Civil Rights Act and then 1972 Title IX, Congress was able to make an important distinction. Our skin color, our racial identity, our ethnic heritage is irrelevant to what we do in the bathroom, the locker room, what dorm we live in, what sports team we play for. But our male and female bodily nature is relevant. And so that's not considered discrimination in the first place. You can have separate soccer teams for your men and your women athletes. You can have separate dorms for your male and female students. What you have to do is you have to make sure they're equal. Right? And so the implementing regulations say that yes, you can have separate athletic facilities for men and women, but you can't give men like gold-rated locker rooms while women have leaking plumbing and outdated sports facilities. You can have separate facilities, but they have to be equal. Separate but equal is an anathema in the context of race discrimination. So Congress is going to make a distinction here between we're not allowing separate but equal in the context of race, precisely because what motivates the desire to separate races is an idea that whites and blacks shouldn't be interacting on an equal basis. What motivates the separation of men and women in athletics is that it's unfair to have men and women competing against each other. That physical bodily differences, let's say you're taking something like boxing or wrestling, it would be unfair and unsafe in some contexts. Likewise, when it comes to privacy interests, you might not want to have your male and your female students sharing the same locker room or the same shower facility. So Congress makes this distinction, which is simply to say that it doesn't define it as discriminatory and then grant an exemption to faith-based institutions. It says it's not discriminatory in the first place to recognize bodily sex in certain situations, but it is discriminatory in other situations. You can't do home ec and macroeconomics based on sex. In addition to this, Title IX grants a waiver to any religious school that asks for one. You can simply petition the Department of Education and simply ask to be utterly exempt from the law on Title IX. So it's making a distinction between secular educational institutions, including government-run educational institutions. Title IX is a federal law that applies to many state schools, public schools, if they receive federal funding, which all of them do. So it's a federal law that actually regulates all of our public schools and all of our private institutions that receive federal funding, which is like everyone except for 5 colleges, including like Hillsdale, Grove City, Christendom, and 2 others that I always forget. But it says that those private faith-based institutions can be exempt because we recognize that Orthodox Jews, Roman Catholics, Mormons, evangelicals, there are all sorts of distinctive religious teachings that are legitimate and appropriate when it comes to men and women that we're not going to have the federal government meddle with. We're not going to have the federal government try to decide who should be ordained and therefore who should be taking ordination track classes on college campuses. Or we're not going to try to decide how Mormons view the relationships of men and women. We're going to let religious institutions handle this for themselves, but secular institutions will be governed by Title IX. So that's a law that recognizes that sometimes distinctions based on sex are discriminatory and sometimes distinctions based on sex are legitimate. And it's appropriately nuanced, and then it has some religious liberty exemptions, unlike our racial discrimination laws. Let me give you a third category of cases. Cases where people might claim that someone is discriminating, when in reality they're neither discriminating nor distinguishing based on the underlying characteristic. And the clearest example of this is pro-life medicine. So some people have claimed that the reason that a pro-life doctor is pro-life and won't perform an abortion is because of sexism. is because of misogyny. It's because of the patriarchy. And that pro-life doctors are refusing to treat women equally. And they're holding women in a second-class citizenship category by not performing abortions. And thankfully, the Supreme Court has never accepted this argument. Whatever you think about abortion, it's not the identity of the pregnant person that determines the conviction of the pro-life doctor who says, I can't kill an unborn child. And one of the easiest ways of illustrating this, now that we have kind of like mainstream transgender identities, is that a pro-life doctor won't perform an abortion on a pregnant man or a pregnant woman. The gender identity or the sex of the pregnant individual plays no role in the decision-making process of the pro-life doctor. So there's a 1993 case, Bray v. Alexandria Women's Health Clinic, that reaches the Supreme Court. And one of the arguments was that pro-lifers are discriminating on the basis of sex, and this violates an anti-discrimination law. And the Supreme Court rejects this, writing, quote, whatever one thinks of abortion, it cannot be denied that there are common and respectable reasons for opposing it, other than hatred of or condescension toward, or indeed any view at all concerning women. And so the Supreme Court says, look, whether you're pro-life or pro-choice, we don't have to give in to the lie that pro-life doctors are doing this because of hatred of women or condescension towards women, or indeed any view at all concerning women. It's not based on the identity of the pregnant person that the doctor can't perform an abortion. It's based on the dignity, as the doctor understands it, of the unborn child. So now we're having similar types of cases come up in the sexual orientation and gender identity context. And the question is, where should we be locating these cases? Are they more like racial discrimination? Are they more like sex-based discrimination? Or are they more like pro-life medicine, where the identity of the individual isn't what's driving the decision-making process of the person who's being accused of discrimination? So let me go through a couple of cases like this before turning to Jack Phillips and wrapping up there. Take the example of a Catholic hospital, two of which are being sued right now, one here in California and one in New Jersey, that won't perform a sex reassignment procedure. Are they doing this based on, let me get that quote up again, hatred of or condescension toward, or indeed any view at all concerning transgender people? Is their viewpoint that we hate trans people, we're condescending towards trans people, or are they saying, whatever you think about transgender identities, we don't remove the healthy uterus from anyone? Right? Catholic hospitals don't perform sterilizing procedures on anyone. It's actually a long part of Catholic teaching. They won't perform vasectomies on men who want to sterilize themselves that way. They also won't perform elective hysterectomies on women. And they certainly, in this case, won't perform a hysterectomy on a woman who wants to become a man. Not because they're anti-trans, but one, they don't want to mutilate the body and render someone sterile. And then two, there's a disagreement about the nature of medicine and the appropriate therapeutic response to gender dysphoria. Some people in the medical profession argue that sex reassignment is the appropriate response to gender dysphoria. And if you have someone who experiences gender dysphoria, the distress at their own bodily sex, the way to relieve that distress is to help them transition to living as the opposite sex. Other people say the appropriate therapeutic response are various forms of psychotherapy, various forms of talk therapy, to help someone align their thoughts and their feelings with the reality of their body, rather than transforming the body to align it with their thoughts and their feelings. Now, this strikes me as very much like the abortion debate. There are good arguments on both sides, there are reasonable people on both sides, and it's not based on discrimination. What would be a clear example of gender identity discrimination in this context? Imagine that same hospital said, we won't do chemotherapy for you because you identify as transgender. Right? That strikes me as much more like a racist hospital that would say, we won't treat you because you're black. Or the racist hotel that said, we won't rent you a hotel room because you're black. Or the racist business that said, we won't employ you because you're black. Right? In the one case, they're taking the identity of the person into consideration, where the identity doesn't matter, in order to treat the person less than equally. to treat them as a second-class citizen. And so a hospital that says no chemotherapy for you because you're trans would be discriminating on the basis of someone's gender identity. But a hospital that says we won't perform an elective hysterectomy on anyone, whether it's for explicitly sterility purposes or for sex reassignment purposes, isn't discriminating on the basis of gender identity, because nowhere do they take the gender identity of that patient into consideration. They don't perform elective hysterectomies on men or on women, trans men or trans women. Let me give another example. Let's say, in this case, rather than using gender identity, we'll use sexual orientation. Catholic Charities has been forced to shut down adoption agencies in several states. And right now, the ACLU is suing the state of Michigan for refusing to shut down Catholic adoption agencies. Michigan passed a law maybe a year and a half or 2 years ago now that said that faith-based agencies could continue to operate and can continue to participate in government grant programs and partner with the government when it comes to the care of foster children and orphans, which is a virtual requirement if you're going to be doing work for foster care and adoption, because children, when they're removed from families, they become wards of the state. And so if you're going to be doing foster care and adoption services, at some point you're going to be interacting with the government. And so what Michigan said was that we're not going to penalize faith-based institutions who work to find children homes with married moms and dads. And the ACLU is suing Michigan, saying this is discrimination on the basis of sexual orientation. And other states on their own have concluded that Catholic Charities is discriminating on the basis of sexual orientation. So in Massachusetts, in Illinois, and San Francisco, and in Washington, D.C., Catholic charity adoption agencies have been forced to shut down, no longer able to help children in need find homes. Now, what is Catholic Charities' thought process here? Are they saying that gay people can't love kids and therefore we won't do same-sex adoptions? Are they saying gay people are bad people and therefore we won't do same-sex adoptions? Or are they saying men and women are different, mothers and fathers aren't interchangeable, and children deserve both a mother and a father? That the true best dads in the world, regardless of their sexual orientation, can't replace a missing mom, and the two best moms in the world, regardless of their sexual orientations, can't replace a missing dad. Now, agree or disagree with Catholic Charities on that particular belief, it has nothing to do with the sexual orientation of the prospective parents. What it is saying is that sexual complementarity and gender diversity matter. What it's saying is that both men and women are crucial for the developmental process of a child, and they simply want to be free to continue doing this. Same-sex couples in all 50 states are legally allowed, not legally allowed, they have to be legally allowed to adopt from all the government-run adoption agencies, and the majority of private adoption agencies choose to do this. So if you're a same-sex couple in all 50 states, you can go to any of the state adoption agencies, adopt the child. Why does the government have to say Catholic Charities adoption agencies have to do this? Right? That's the illiberal part of the liberalism that we're seeing. It's not a live and let live, it's my way or the highway. The law is not being used as a shield to protect a beleaguered minority, it's being used as a sword to punish an entity that actually is increasingly a beleaguered minority. Right? It's not protecting the same-sex couple ability to adopt. They can go to any of the state agencies. It's a sword telling Catholic Charities, unless you do it our way, you can no longer do it. Which is particularly appalling because Christians of various stripes have been caring for widows and orphans longer than the United States of America has existed. And now we have secular governments telling them they can no longer do this charitable work. It's also, if you're just a pure utilitarian, many of these faith-based adoption agencies do a significantly better job than the government-run agencies. So imagine what your experience is like at the DMV, and then imagine what the DMV of foster care and adoption looks like. Catholic Charities has a track record of placing some of the hardest to place kids into permanent loving homes. Chalk it up either to grace or to Catholic guilt. But they're able to get families to be more generous, to open up their hearts and their homes to more children, including the ones that aren't as, quote, desirable. What I mean by that is lots of people want to adopt newborn babies. They're cute and they're cuddly. Not nearly as many people want to adopt 10-year-old boys with behavioral problems who have bounced around from foster home to foster home. And the Catholic adoption agencies were able to get families to adopt those kids. They're able to help mothers facing unplanned pregnancies to choose life and to place their children for adoption rather than aborting their children at Planned Parenthood. And they're able to walk with the families. Adopting a child, it's not like renewing your driver's license. They're going to be emotional, spiritual needs, not just physical and material needs. And a faith-based agency can minister to the entire family, both the material needs and their spiritual and emotional needs, which is why they have such a great track record of doing this great work. Why would we now want the government to in any way penalize them for this? Okay, so, and the contrast there, since that was the sexual orientation example, imagine a charity, a soup kitchen, for example, a Catholic soup kitchen that said, no food for you if you're gay. That would be discrimination on the basis of sexual orientation. Gay people need to eat. Gay homeless people need to eat. Here you would have someone taking the identity of the person in need into consideration where it's irrelevant for the purpose of what's going on, feeding hungry people, in order to treat them less than equally. And so you could make a case that the soup kitchen that won't serve gay people is discriminating on the basis of their sexual orientation. But the adoption agency that only does adoptions for married mothers and fathers, at no point does sexual orientation enter into its decision-making process. What enters into the decision-making process are that men and women, mothers and fathers, both matter. All right. So let me, in the time I have left, turn to Masterpiece Cakeshop. Jack Phillips is an evangelical. He runs a bakery in just outside of Denver, Colorado. It's in Lakewood, Colorado, if I remember it correctly. He serves all of his customers, but he can't help them celebrate all events, and he can't communicate all of their messages. So over the course of his, I think it's now 15 or 20 years that he's been the owner of Masterpiece Cakeshop, he's had to turn down a number of requests, not because of the identity of his customer, but because of his identity as an evangelical Christian. Because of his identity as an evangelical, there's certain messages he can't communicate. There's certain events he can't celebrate, regardless of the identity of the person who asks him to do it. So over the past 15 years, he's been asked to do bachelor party cakes with lewd images. And he says, that's not a message I can send. He's been asked to do cakes with alcohol. He says, I can't do that. He's the type of Christian that doesn't drink. That's not my type of Christian. But religious liberty is, it's the right to be wrong. And so he won't do any cakes with alcohol. He's been asked to do anti-American cakes. And he's the type of patriot that says, I'm not going to make a cake that communicates a message that's anti-American. What else? He's been asked to do Halloween cakes. He won't do any cakes for Halloween because he doesn't think we should be celebrating Halloween. He's also once been asked to do a cake celebrating a divorce, a happy divorce cake. They wanted to make a traditional 3-tiered white wedding cake and cut it in half and just deliver half of it to symbolize the divorce. And he says, look, that's not an event that I can celebrate. It's not a message that I can send. In none of those cases, the divorce cake, the anti-American cakes, the bachelor party cake, the Halloween cake, the alcohol cakes, and actually one time he was asked to do an anti-gay cake. And he said, I can't do that either because it's not the way that this, the message, it was something terrible, like, oh, I forget now exactly what it was, but he's like, that's not the way that we should be expressing the message. So he said, I can't do that cake either. In none of those cases was he found to be guilty of discrimination. In fact, as far as I know, none of those cases was even a complaint lodged against him. In all those cases, people are like, all right, fine. Those are your beliefs. They might not be my beliefs, but you're an evangelical baker, and I'll just go to a different baker. The reason Jack Phillips names his cake shop Masterpiece Cakeshop is for two reasons. One, as a high school student, he was drawn to all of the art courses. And he views himself as an artist. And so his logo is a painter's palette with a French whisk. And that what he's doing is he's combining his love of art with his love of baking. And long before this case developed, one of the Denver newspapers ran a profile of him describing his cake shop as a gallery of cakes. So his artistic medium, some people use plaster, some people use clay, some people use canvas. He uses dough and icing, sugar and frosting. So that's part of the masterpiece. Each one of his cakes is a masterpiece. And then second, he takes Jesus's admonition in the gospel seriously when Jesus says you can't serve two masters, God and mammon. And so he views every cake that he bakes as a way of serving Jesus. And so we can only do those orders that he thinks would be in accordance with his Christian principles. And again, whether they're your Christian principles or my Christian principles isn't at stake. The question is whether or not he'll be free to live out his Christian beliefs the way that he understands them. Or will liberalism be illiberal and say he has to do it our way or he can't do it at all? Unfortunately, towards the end of oral arguments, Justice Sotomayor actually suggested that. So let me say a couple of things about oral arguments and how this case could play out. One, in the way that I would like to see it play out, especially given everything that I've said so far, the court could say that Colorado simply got its anti-discrimination law wrong, that Phillips wasn't discriminating on the basis of sexual orientation. And one of the reasons why, as a legal matter, I think the court can actually enter into this, because normally they just have to defer to state courts for the determination of state law. But the Colorado Human Rights Commission actually refers to Obergefell, and it gets Obergefell wrong. It says that the Supreme Court in Obergefell held that opposition to same-sex marriage is tantamount to discrimination on the basis of sexual orientation. But the Supreme Court said nothing of the sort in Obergefell. In fact, Justice Kennedy in Obergefell went out of his way several times to explicitly say that people who support traditional marriage are citizens. Actually, let me get the direct quotes, because Roberts read both of these during oral arguments. And obviously, what Roberts is doing here is reminding Kennedy of what he had said 2 years earlier, because obviously it seems that Kennedy's going to be the swing vote, and I have no idea. This will likely be 5-4, and I have no idea which direction it'll go. So what Kennedy said in Obergefell was, quote, support for marriage between a husband and wife, quote, is held in good faith by reasonable and sincere people here and throughout the world. Kennedy continued, quote, many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. Both of those statements are remarkable because you couldn't say either of those statements about a racist baker. You couldn't have said either of those things in Loving v. Virginia, which is why the court didn't say either of those things in Loving v. Virginia, which is how you can distinguish this case from the case of a racist baker. Because people will always want to say, well, wait, if you rule in favor of Jack Phillips here, you have to rule in favor of the racists, and therefore you're going to be undoing all of our civil rights law. And the answer is no. I mean, you can actually draw these distinctions like we drew between race and sex and now sexual orientation. So Alito then picks up on this, because Alito points out that when Jack Phillips declined to bake this cake, the state of Colorado didn't even recognize same-sex relationships as marriages. They wouldn't grant marriage licenses, nor would they, as in this case, recognize an out-of-town same-sex marriage license. This couple, I can't remember if it was Massachusetts or New York, but they had had their marriage ceremony out of state. They were coming back to Colorado for the reception and the celebration. Colorado wouldn't even recognize the out-of-town marriage license. And so Alito says, this is his direct quote, he points out this reality: Colorado won't even recognize the relationship. Quote, and yet when he goes to this bake shop and says, I want a wedding cake, and the baker says, no, I won't do it, in part because same-sex marriage was not allowed in Colorado at the time, he's created a grave wrong. How does that all fit together? What Alito's pointing out is in 2006, Colorado citizens vote to define marriage as a union of man and a woman. 2 years later, they vote to ban discrimination on the basis of sexual orientation. They want to hold both of those things simultaneously. Anti-gay bigotry is wrong. Support for traditional marriage isn't anti-gay bigotry. Discrimination against gay people is wrong. Support for traditional marriage isn't discrimination against gay people. That's what the law at the time that this case took place, that's what it said. And so Alito's pointing out, how can you have a situation where now the baker has violated the anti-discrimination law when the legal definition of marriage was what the baker was acting on? And then Kennedy gets in on the act. And this is an encouraging part. It hasn't been as highly noted. But Kennedy, in the exchange with the ACLU attorneys, so both the ACLU and the Solicitor General of Colorado, were the opposing parties. And then you had an alliance defending freedom attorney and the US Solicitor General defending Jack Phillips. And so in an exchange with the ACLU attorney, Kennedy's saying, look, he's not discriminating on the basis of sexual orientation. We just have a disagreement about what marriage is. And not every disagreement is discriminatory. And so Kennedy, quote, look, suppose he says, I have nothing against gay people, but I just don't think they should have a marriage because that's contrary to my beliefs. It's not their identity, it's what they're doing. And then the ACLU attorney responded, that is just identity-based discrimination, that just is sexual orientation discrimination. And then Kennedy responds, quote, your identity thing is just too facile. So Kennedy seems, at least from oral arguments, to want to be able to draw a distinction between identity-based discrimination, where it's because of who the person is that you're treating them poorly, less than equally, and then a different understanding, which is what you just have a belief about abortion, about the sanctity of life, about the definition of marriage, about healthcare for gender dysphoria, which is a reasonable disagreement where we have to agree to disagree. Right? We can be liberal about that. We don't have to be illiberal. Let me wrap up by saying the other way this could go is a free speech argument, a compelled speech argument. And that they spent lots of time during oral arguments there. The argument here is that the Supreme Court has robust jurisprudence against compelled speech. The freedom to speak is also the freedom not to speak. And the government can't force you to speak the government's message. And a wedding cake is an inherently artistic creation in a celebratory context, which conveys a message. So if you walked in here and we had a cake sitting on the table, you could tell from a certain sort of cake what event we were celebrating. Is it a birthday cake? Is it a wedding cake? If you came in here and it was a birthday cake and I told you, oh, no, this is for my wedding reception, you would think I got gypped by the baker. And so there's certain types of cakes that communicate things, which is why people spend so much money for their wedding cake, but not their wedding salad. There's no such thing as a wedding salad. Right? And no one, if we had a bunch of salads sitting on the table, you wouldn't be able to say, oh, we're celebrating someone's birthday or wedding. But from the cake, you can. So it's an expressive piece of art which communicates something in an inherently celebratory context. That's all you need for compelled speech. And there are two Supreme Court cases that come with sexual orientation discrimination charges from the states in which the Supreme Court once unanimously and once 5-4 rules in favor of First Amendment freedoms. One was a compelled speech case. It's the Hurley case, Irish Citizens of America v. Hurley, or Hurley v. Irish, I forget now which order it was, but it's a 1995 case. It involves the St. Patrick's Day Parade in Boston. This is organized by a private group, but it's on public property, and it was governed by Massachusetts's public accommodation statute, which banned discrimination on the basis of sexual orientation. A group of gay Irish Americans asked to march in the St. Patrick's Day Parade under a banner that supported gay rights. And the organizers of the parade said, no, you're welcome to march in the parade as Irish Americans, but not as gay rights activists who are Irish Americans, because you will be changing the message of the parade. The parade is meant to be celebrating Irish heritage and identity. You're now going to be inserting a political message that we don't support. The state of Massachusetts said this is discrimination on the basis of sexual orientation, which is prohibited. And then the Supreme Court unanimously, in an opinion written by Souter, said no, that this would be compelled speech, which violates the First Amendment. You can't apply your anti-discrimination statute in this way. 5 years later, in Boy Scouts v. Dale, the question, this was, now I'm actually blanking, I think it was gay scoutmasters, not gay scouts at the time in the Dale decision. And the Supreme Court ruled 5-4 with Kennedy in the 5. So Kennedy in the majority, saying that the right to expressive association is that you have to be able to associate according to your own identity. And so the Boy Scouts have a certain identity. Part of the Boy Scouts pledge is to be morally straight. They interpreted that to entail no same-sex conduct from either scouts or scoutmasters. So now it'll be interesting to see what happens. We're expecting a decision at the end of June. It'll be one of the bigger cases from this term. They could go a compelled speech route. They're going to be hearing oral arguments later this month in a similar compelled speech case, whether or not pro-life pregnancy centers have to advertise for abortion. So they might go a compelled speech route. They might go you're not drawing the right distinctions on how to define and legally apply anti-discrimination laws. It's also possible that they rule against Jack Phillips, which would be a huge setback. It would be a win for illiberal liberalism, because it raises all sorts of questions about what will happen to an institution like Trinity. Will Trinity Law School retain its accreditation? Will it retain its nonprofit tax status? If it has, I don't know what your policies are, but if it has historic Christian beliefs about marriage that it then acts out on in its campus policies. So it's not just whether or not a baker will have to bake the same-sex wedding cake, but this will have implications for faith-based educational institutions, for faith-based charities, for Orthodox Jews, for Roman Catholics, for evangelicals, for Latter-day Saints, for Muslims, for anyone who believes we're created male and female, and that male and female are created for each other. So quite a bit is at stake here, and thank you for your time.
Well, it is great to be able to talk about issues that invoke to some extent natural law thinking on this, the feast day on the liturgical calendar for St. Thomas Aquinas. So it's fitting that we gather together for this kind of discussion. I wanted to talk a little bit about the social context that makes it possible for a case like Masterpiece Cakeshop to make it before the Supreme Court, and for us to talk seriously about the rights of a baker to make his own wares in a way that would have been unthinkable to us 50 years ago. I think the case would have struck us as absolutely bizarre and not raising any constitutional issues at all. I think when it comes to social change, in regard to how a society changes its viewpoints about something throughout history, but we'll talk about the current American context, the change that makes a difference in how people behave often starts with changes in the law, primarily through legislation. But once legislation is passed, if it is thrust on an unwilling society, there's another battle in enforcing the law, getting the police to care about enforcement and getting prosecution possible. Once that battle is over, there is still a social battle for those that aren't persuaded that the change is an appropriate one. I think we can trace this through American history in race, in that in the long run of Jim Crow laws, where we had government-sanctioned racism. We saw that battle substantially over as a matter of law by the mid-1960s. That is, the legislative battle and the court battle had been completed. It didn't mean that racial activity changed at all anywhere, because we still had people in control of the reins of power that were racist and didn't agree to the change. So they continued to behave as if legislation and court decisions hadn't changed. And that continued, I think, roughly until the end of the 1970s. By 1980, I think it is fair to say that on racial issues, our government employees at all levels were primarily on board and enthusiastic about eliminating racism from government action. So for all we can say about social issues of race and tension today, it has not been because the government, for the most part, is reluctant to embrace integration at the racial level. That is not to say that at low levels of government there aren't a lot of outliers that are counter to overall trends, but we have in this country a national government that is passionately interested in race not being a social issue any longer, a matter of dissent any longer. The third battle is the battle for hearts and minds. And often in a nation like ours, where the progressive movement is way ahead of the rest of the culture, this is the laggard. Now, as it turns out, there are many people who are largely indifferent to these issues that will change their minds because the law is a moral teacher. When the law says racism is wrong, there's a huge chunk of middle America that will say, okay, I guess it's wrong, and I'll modify my behavior, and there's not much thought given into it. But there are many others who are set in their ways. They don't see a particular reason to change. And in the area of race, not to disregard many of the issues that are problems today, but for the most part, we have a nation where racial equality and equal treatment are embraced completely. I think the best example of this that I can give is when two white people are engaged in a conversation, or you have a group of white people where there's a conversation in which one of them takes profoundly offensive racial opinions. Nobody's social status is at stake there, but there is generally moral approbation for somebody like that, and they tend to shun them afterwards. That is how society has changed, and the change has come to a great extent by the moral force of religious people. The idea that we're all made in the image of God, as it trickles down through all aspects of thought throughout society, tends to suggest that finding a distinction based upon race is not relevant for any aspect of society. Now let's shift over to the issue of same-sex status in the nation. We have had laws over the past 20 years that have equalized the playing field to a great extent for homosexuals, that particularly since Lawrence v. Texas, it has been the case that all legal rights available to heterosexuals are available to heterosexuals, that homosexuals don't have to fear prosecution for homosexual activity, and a lot of law has changed to have that filter out through all aspects of our legal system. The laggard has been government employees. We've had, just in the post-Obergefell era, examples of court clerks that did not want to go along with the legal program. But I think that is changing because we have a government that is enforcing that kind of conformity. The remaining battle is the battle for the hearts and minds of the nation. And what the same-sex marriage and homosexual advocates want is embracing of the goodness of their viewpoint. And that will not happen. It is not the same issue as race. There aren't the same kinds of religious issues that can be drawn on to resolve the matter. And to a great extent, those who have been moved along socially to embrace same-sex marriage, for an example, is the pivotal issue now, are doing, I think, entirely by using race as a proxy for same-sex matters. That is, how does the otherwise indifferent person on the nuances of how bakeries operate have a strong opinion about why somebody should be able to go into a bakery and ask a baker, demand that the baker create a cake that the baker doesn't want to bake. We all get to that issue by using the racial issue of hotel and restaurant treatment of those who are traveling cross country. If blacks are not welcome at hotels or restaurants, it's very difficult to travel. And to the extent that you buy that as a complete proxy for same-sex wedding participants seeking to get a cake, then that resonates. To the extent that you see them as different, it doesn't. And modernly, that proxy issue has been shifted to an expectation that somehow dignity is endangered by allowing this kind of effrontery to take place for those that seek to have a cake made. But that argument seems to break down in that if it truly is about dignity, why would a person looking for cakes go to a bakery where they know they're going to get snubbed? There are other bakeries available. Why don't they go there? At least on resolving the dignity issue. The only reason why this resonates is this not an exact proxy for the kind of situation we had when we had codes in America that made it impossible for travel to be easily undertaken by Black Americans. Because it is a battle over seeking legitimacy for a viewpoint that others reject as being wrong or sinful, the battle is going to take place on some of the more strange side issues. It's odd that the issue of same-sex marriage comes down to a battle over whether a cake could be made or not. But this is where it places us. And to go to the illiberality of liberalism modernly, a rejection of the basic tenets of liberalism, a wide tolerance of divergent viewpoints, comes down to issues that are just hard to see how people can change their minds. One thing that resonates with me on this this case in particular is David Cole, one of the attorneys who argued before the Supreme Court, teaches First Amendment law at Georgetown. And I had him as a professor in his first year as a professor. And law school for me was a time of exploring the First Amendment. And I became persuaded that I was kind of a First Amendment extremist. And happily, David Cole agreed with me. He was a Justice Black style expansionist supporter of unfettered free speech rights. And yet here he is 30 years later, and he's arguing that our Constitution dictates that speech rights be contained because they're offensive and they violate the other more privileged rights that are faced by our society. So on that, I think it leads to a kind of strange state because we do have illiberal liberals where much of the argument that advances civil debate in our society is gone. And to look at an issue completely on the liberal side, the attitude that the homosexual community generally has had towards the current transgender debate is kind of a remarkable thing. There's an inconsistency in viewpoint there, and that historically those on the vanguard of homosexual rights have encouraged a less binary view of sexuality and encourage a sliding scale idea of sex, where in contrast the transgender movement is extraordinarily binary. It's founded upon stereotypes of male and female roles, and yet the homosexual community has advanced the transgender movement as being of the same style and source of argument, of authority for the argument. And it is difficult to see how this will play out, but I'm curious. I hope we have some dialogue on our prognostications of how the case is going to come out. But it is a strange time in our history to see that there's been such a shift, and it's hard to predict what is going to come out next. And with that, I'll take a seat and we can talk a little bit further.
Do you have anything else you wanted to add?
We can go right to questions.
Do you have any questions?